Advocate Nikita Pandit and I will be speaking on the copyright law in the USA, and you are watching Legal Bites. Now the main objective of this video is to understand the legal provisions related to the copyright in the USA and its interpretation by the courts. As we had seen in the previous video, copyright is a bundle of rights. It is an intellectual property belonging to the authors of the creative works. Copyright law in USA has its source in the Constitution of the USA in Article 1, Section 8, Clause 8. The Constitution has given the power to the Congress to do all such acts which are necessary for promoting the progress in the fields of science and useful arts. It gives some time-bound exclusive rights to the authors or the creators of such works. Copyright protects the works of the authors in artistic works, dramatic works. The protection to the copyright work is provided by Title 17 of the US Code, which was incorporated in the year 1947. The first legislation which was passed for copyright protection was the Copyright Act of 1909. It was made to consolidate and amend the copyright law in the USA. It provided for the exclusive rights given to the authors of the works, such as right to copy the work, right to reprint, right to publish, translation in some another language, adaptation in some another form. Several other rights were also included, such as rights in TV shows, rights in sounds, in movies. These all were brought under the umbrella of copyright. We had also seen that USA was a member of various international conventions. Now, in order to comply with the minimum standards of protections which were laid down by these conventions, especially the Universal Copyright Convention, USA passed the Copyright Act of 1976. This Act of 1976 was considered as the basic structure of the legalities associated with the copyright. After that, in order to keep up with the advancements in the technology, USA passed the Digital Millennium Copyrights Act in 1998. Now, this act was passed to encourage the authors of different work to publish their work in digital forms and to ensure that the work which was published online on the internet had adequate protection. It also ensured that the WIPO Copyright Treaty and WIPO Performances and Phonogram Treaty were incorporated in the copyright law of USA. Copyright protection is given to the work which is in some tangible form. It means that there is no protection given to the ideas if they are not put down in some graphical form. Such expression of ideas can be in the form of words, notations, videos, photos, symbols, or in any other medium. Only then it can be copyrighted. The works that can be copyrighted are literary works, dramatic works, cinematographs, graphics, sculptures, sounds, architectural works. This is provided by Section 102 of the US Code. 103 of the US Code provides for the protection of derivative works and compilations. Now, what is a derivative work? It is a work that is taken from some other work that already exists. The best example is movies that are made from the plays or remix of music. Okay. For example, a sculpture which is made from a sketch. And compilation is putting together information. Now, there is some criteria that is to be fulfilled. For example, the compilation must be done by using mind in selecting the information to be put together from a vast pool of information. It should be arranged in such a way that it results into some new creative work. For example, a book of photographs. Now, these photographs are already copyrighted, but when a person applies his mind and skill to arrange it in a complete new manner, it is called as compilation. For example, we can take categorization into landscapes, portraits, wildlife, further based on colors, red, blue, green. Another example is a journal, which consists of various articles by different writers on different topics. Copyright is the protection which is given to the authors of the work which are original. This is for a limited period. The period is lifetime of the author and another 70 years after the death of the author. In case of joint ownership, it is 70 years after the death of the last surviving author. The initial ownership of copyright is considered to be that of the author. Now, in case a person is in employment of another person or works for hire, his employer will have the ownership of copyright. Copyright can be transferred by conveyance, such as it can be given on license, it can be sold. It may also devolve upon the successors after the death of the author. There are two main requirements of the work that needs to be fulfilled. Okay, the work should be original and it should be in some tangible form. Now the term original is used in a very general sense because original is a relative concept. It changes depending upon the cases. So it cannot be defined as such, but it can be understood with the help of case laws. In USA, there was a landmark case of Feist Publication versus Rural Telephone Services. Now, Rural published a telephone directory having white pages and yellow pages. Feist covered a wider area than the Rural and wished to get some part of Rural's directory on license basis. Rural denied them the license, so Feist extracted that part without Rural's consent. Now, this was the case of compilation. The court held that the publication by the Rural was a raw data and it contained facts. Such work cannot be copyrighted. It had no creativity, originality, there was no mind applied in the selection as it was mere arrangement in alphabetical form. So there was no question of copyright. Another criteria that we saw was it should be in some tangible form, which means it should be expressed in some medium like on a paper or a movie. It can also be expressed by using some devices or machines like computer output or mobile screen. In one case, White Smith Publishing Company versus Apollo Company, the court held that this provision of copyright depends upon the facts of the case, depending upon the medium. There is no distinction made between the mediums, but the work should be expressed in some form. It can be words, symbols, notations, or in any other manner. It can be print media, digital media, or photographs. It should be in some physical medium. Section 106 and 106A provide for the rights that are given to the copyright owners. They have the right to reproduce their work, to make the copies and use it. It may be for storing or it may be for getting the financial benefits from it. Such reproduction must be expressed in a permanent medium, because if it is on a temporary medium, it is called as display. It is not reproduction. Another right given to the owner is making the derivative work that we covered earlier, that work which is taken from the already existing work. The owner has the right to perform his work in public. For example, a drama, he has a right to get it performed. In case of a singer has a right to sing in public. The sound recordings, audio visuals can be displayed in front of public. The example is showing movies in the theaters or selling the CDs. Also, in case of sounds, playing the sounds in public. Now, these are certain rights which are provided to the copyright owner by the law. The author of the work also has one more right, that is right to be associated with his work, to make sure that his work is not destroyed or altered or mutilated. The previous rights that we have seen were economic rights, and this right is the moral rights. The Visual Artists' Right Act of 1990 for the first time gave the moral rights to the authors of being associated with their work even after parting ways with the work. In one case, Grants versus Harris, it was a case of phonogram recording. Now the sound record was trimmed considerably and sold to the public in the name of that artist. The court held that when substantial changes are made to any work and sold in the name of the author, it amounts to distortion. This leads to unfair competition. However, if these changes happen to the work because of being there for a long period of time, for example, wearing down of the pages because of being stored in the library of this is with respect to the book, or changes which are caused because of conserving that work or due to the lights, due to the storage, and because of this, if the work is depicted or portrayed in some another form, it is not hampering the moral rights. The author is also given an option to waive off his moral rights. Section 501 provides for the infringement of copyright. So when someone acts in violation of the before mentioned exclusive rights of the owner, it is called as infringement. The violation can also be made by state and state bodies. So in order to take action against the unauthorized use of copyright, the owner of the copyright has to serve a notice to the infringer along with the complaint copy. This violation also includes secondary transmission, which is done by the cable companies. In such cases, the primary transmitter or the license holder also has the right to enforce action against such violation. One example is Callum Company versus Harper Brothers, where the photos were arranged in a film to make a motion picture showing the substantial part of the work of the author, and then putting the same in their work and selling it is an infringement. Another case is Ericsson Productions versus Cast. In this case, the photographs of the plaintiffs were shown on the website of a person. The defendant had hired the developer for his work. The plaintiff's photos were licensed to a bank and these photos were put on this website. It was held that there was contributory liability of infringement. Such is where there is a reason to know that it is an infringement, but it does not directly infringe the rights. Now, when the use is made for the purpose of criticism, for news, for teaching, archival, or making copies for replacing the copy which is damaged or lost or stolen, an effort is made to retrieve the copy, but there is no possibility of getting the same. This constitutes the fair use. Fair use is used as a defense against the copyright infringement, when such acts usually result into infringement but are not considered to be infringement in some circumstances. The test to determine the fair use is, the first point, the purpose of the use, that is, if the use is commercial use or if the person using it gets any benefits from that use. The second point is, what is the nature of the work that is copyrighted. The third point is whether there is material copying of the work done, and the fourth point is the effect on the potential market. Now, the burden to prove the infringement lies upon the plaintiff, but when the defense is taken of fair use, the burden to prove the same goes on the defendant. There is one case, Google LLC versus Oracle. This was decided by the Supreme Court of USA, wherein the fair use was determined of a computer program. Now, Oracle was the owner of the copyright of a Java program which could be used in any devices such as laptop or desktop. This gave directions to the computer for performing certain tasks. It showed how the task is to be performed along with the location. Google then created a program for Android and it used several lines from the Oracle's program. The declaration code was something more than the computer program. So Oracle's code was a declaration code. Court did not find any evidence that the code which was used by Google was for the same purpose as that of Java. Java had used it to direct the computer to perform certain tasks. The court held that the use that Google had made was transformative by adding something new to it. Something significant was added to the work of Java. Further, the developments were made into the Java of Oracle to bring something new to the use of mobiles. Now, considering the quantity of the work that was copied by Google, the court held that the copy constituted only 0.4% of the total Java code. It was used only for transformation into a new declaration code and was only for the purpose of the Google to use it in Android by allowing the Java program to be used so that the existing knowledge of the Java can be used by putting something new into it. It did not hamper the profits of Java as they both were operating in different fields. To enforce the rights in copyright and to file a case against the infringement, the person can approach the civil courts for the action of injunction to stop the infringement by the infringer. This is under section 502 and 503. The court has the power to impound or seize such infringing material during the course of proceedings. Section 504 provides for the remedy of damages, that is claiming the profits which are earned by the infringer. The proof is required to be given by showing the revenue and accounts. Another option is statutory damages, where the court can award the damages, that is compensation, from $750 to $30,000. And if it is found that such violation was made on purpose, it can be increased to $1,50,000. On the other hand, if it is seen that such act was not done intentionally, it can be reduced to $200. Attorney fees can also be claimed. Section 506 also makes infringement a criminal offense if it is made to make money out of it. If such copies are made and distributed for a particular value more than $1,000, or if such work is made available on the internet, it is a felony. The limitation of civil action is 3 years and criminal action is 5 years. Now, something about Digital Millennium Copyrights Act of 1998. It incorporated the standards of WIPO Copyright Treaty and WIPO Performances and Phonogram Treaty. In this, the service providers of online material were given certain protection if they displayed the work without hampering, or just if they use the work just for storing so that it can be showed online, such as if the work is stored so that it is to be streamed on the YouTube. Okay, so such service providers were given some protection. It provides a platform for transmission. Now, service provider, they just give a platform. They cannot be held liable if some person puts some infringed material. Now, in case of cable TV operators, okay, they can store the work for the purpose of transmitting the rightful work by the licenses. It also provides protection to the storage of work for the purpose of saving it if at all there is some fear of losing it in case there is some maintenance coming up or repair is to be done. For example, if the computer has to be repaired by completely erasing the memory, so the person saves the purchased software in some CD or a pen drive. Now, in this case, it is protected by the law. Now, these are certain important provisions of the copyright law in the USA. Thank you.